Hi everyone, let's talk about child's voice in a custody proceeding. Let's say your 13-year-old tells you, I want to live with my dad and your mom, or vice versa. Does that mean the child has the final voice? Well, no. No age up until 18 allows the child to have the final voice. Code section 3042 Family Code states the court must consider child's wishes if the child wishes to testify, but the court still has the discretion to determine what's in the best interest for that particular child. So, for example, we have a situation where a child says to mom, and they have 50-50 visitation schedule, I want to live with dad full-time. And when you inquire, why so? Well, dad has less rules. So you are the stable parent who does the homework, who brings the child to school, so is the other parent, but in the other household, they can watch TV, they can watch an iPad, play games, and then the situation arises when the other parent files a motion to modify child visitation to say, well, child wants to live with us. And the question then becomes and arises, how will the court determine what to do? So the court could have different options how to hear the voice if the child is over 14, according to 3042, direct testimony. Well, direct testimony in court could be intimidating. I rarely have seen any child testify. So then the second option would be to have the judge speak to the child in chambers, which is in the judge's room, where it's less intimidating. There are no court reporters, there are no cross-examination questions. It's more judge figuring out what the child wants in chambers. That's not ideal because it does put a lot of pressure on the child, and it could be still intimidating. So the third option is appointing a minor's counsel. A minor's counsel is a lawyer for the child. So the child would meet with a lawyer, would be attorney-client relationship, and then the child would tell the lawyer why the child thinks it would be best to stay with dad. And the child would say, well, I can eat whatever I want. What do you eat? Well, I eat candies and I eat French fries, and mom only lets me eat vegetables. I'm just giving you extreme example. Of course, it could be some gray area. And mom asks me to do the homework, and with dad, I created this book to help you understand the divorce process without getting lost or without getting a heart attack. You can buy it on Amazon in all formats, including audio format. And then the minor's counsel will come to court at that hearing where, let's say in this case, in our case study, father asked for full visitation, full custody, and the minor's counsel would say, although the child's preference is to live with dad, but it is my finding that it would not be in the best interest for the child, and this is why. So you would wonder, wait a second, wouldn't the minor's counsel exactly tell what the child wants? Is that not the job of an attorney to relate what the client wants? No. In minor's counsel situation, minor's counsel has a job to relate the preference, but also evaluate what would be the best for the client. So if someone is representing an adult, let's say adult says to an attorney, I want you to tell the court that I would like my ex to be sanctioned in the amount of $50,000 for filing this paperwork too late. Would that be in the best interest to say? No. The attorney would tell the client, look, this is extreme. I will not say that because it's $50,000 for filing one day late. That's not reasonable ask. And so the attorney would reason with the client and say, well, actually, maybe we can strike that whole paperwork, or we can ask for continuance, or we could ask for, let's say, $1,000 in sanctions. or something like that for violating the rules. That would be a reasonable ask. And in this situation, usually a client who is adult will say, fine, yeah, that makes sense. Although I would like $50,000, I know, I understand. And so the lawyer would say that. With minors counsel, the lawyer is not going to argue with the minor about what's reasonable. The minors counsel could say, well, don't you think that it would be in your best interest to do some homework, not eat French fries and play games until 2 a.m.? The child might listen to minors counsel, but that's not the point. So then you would ask, what's the point of hiring minors counsel if they're not even listening to what the minor wants? So minors counsel job is to determine, is my client mature enough? Yeah, if the child is under 14. If after 14, then assumed to be emancipated, mature enough to state the wishes. And then what's the best for the child? So that's the role in the situation. And the final say, of course, is not the child, not the minors counsel, but the judge. So the judge will listen to mother's side, father's side, minors counsel side, and then determine what is truly is in the best interest for this minor, what type of custody schedule would be appropriate. So it is a myth to say that a 14-year-old child has the final say. It's not true. So just so it's clear. One of my clients likes to say, a child doesn't get to drive the bus to the candy land. So here we are. I hope that was helpful, and I will see you in my next video. Bye!